Welcome, welcome, welcome. Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast. My name is Dan Balkaran, as you see on the screen, and I'm an employment lawyer at Samfiru Tumarkin, LLP, which is, as always, Canada's leading employee-side employment law firm. If you need to get in contact with us for any reason, just a little bit of housekeeping, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821 or 821, 821 5900. I'm going to be, as I said, your employment lawyer for the next half an hour. Please send me all the great questions you've got. I believe we have some queuing up. There's one right now. I don't know the name of this individual. Are you allowed to have cannabis in your possession while at work if you are not using it? My employer found some in our lockers and says he will be docking hours from whoever is responsible. That's a great question. I have no idea. I don't. It's not something I've encountered before. Formerly, that would fall under criminal statute, but of course now cannabis is legal. And is it any different than having a bottle of unopened tequila in your locker? I don't know. As long as you're not, well, let me put it this way. So as long as you're not intoxicated, or I guess with cannabis having consumed any in the workplace, is it a problem that you have it in the workplace? It depends what the specific policies of the employer are, because you could be violating the terms of the your employment contract, or specific policies about having cannabis in the workplace. I don't believe there's any like the employer saying, well, you have this substance, we don't like this, so we're going to dock you hours. I don't believe it has that power, but with all things, or legally has that power, but with all things, what is your recourse, right? And your recourse is, well, you could say you're not allowed to do this and see what they do. You could, if you're provincially regulated, you could launch an employment standards complaint in whatever the employment standards tribunal is called in your jurisdiction. But then your relationship with your employer would be severely impacted. Now, the question is for you, a better question than the one that I just phrased is, if they dock your hours, does it materially, so over 10%, reduce your compensation? And if so, is that a constructive dismissal of your employment? And if so, do you want to pull the trigger on that constructive dismissal because you have a substantial amount of severance coming to you? And so, or you just want to leave, and this is a good way to do it. Those are questions you may want to ask. I suspect docking of hours is temporary. So, you don't have a constructive dismissal where your hours are reduced for 1 week, right? Because it's not a permanent reduction. It's just simply a temporary measure. You may be able to get redress again through, say, the employment standards branch, but there's no point for a few hours here or there and poisoning the relationship with your employer any further than perhaps it's already. And this is assuming you're not a union employee. But if it is a permanent change, then you may have a constructive dismissal, and you may want to speak to an employment lawyer to find out if maybe you should trigger your termination. And if it is a constructive dismissal, just know that you've got effectively 2 months from the date of it's a unilateral change that you don't agree with, this reduction of your hours. You've got 2 hours from the date of the reduction to reject it and effectively trigger your termination. So you may, if that's something you're interested in, you may wish to, and it aligns with sort of the facts that I just said, in terms, well, specifically that the reduction is permanent of your hours, or at least seems to be indefinite for now, and the employer is not providing you any guidance on it. So if you send an email to your employer and say, hey, you reduced my hours by 25%, and is this ongoing, or is this just for a week? And they just say, well, I'll let you know when it changes. Yeah, it's probably a constructive dismissal at that point, but it gets a little difficult for you. Constructive dismissals are hard generally because you have to demonstrate that the term, in your case, that the change in the term, being your 40 hours a week or whatever it is you work, is of it's of sufficient nature, so over 10%, at least in BC, and of a fundamental nature. So hours will get you there, but things like scheduling might not, depending on the situation. So, but it can't be fundamental if it's temporary, and if you don't know, then you're saying I had no idea, so I have to take this as a permanent change because I'm circumscribed by the 2 months, 2 month time limit to trigger your constructive dismissal, and that's a good argument. And on the other side, they'll say, no, this was just a temporary thing. We were going to, increase his hours back to, 40 hours a week shortly. And in that, there's a lot of risk for you. So you'd never get 100 cents on the dollar, probably more like 50 cents on the dollar, 60 cents on the dollar, something like that. So a lot going on with that question. But the core of it is is there a mechanism at law by which, or at least the core of your question, a mechanism at law by which they could tell you're not allowed to have possession of cannabis at work? I don't know, but I doubt it. But it could be part of their policies, in which case you're violating a policy. Anyway, if you are interested in perhaps pulling the trigger on a constructive dismissal and effectively terminating your own employment to get severance, you should talk to an employment lawyer right away. You can do that by contacting us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, question, again, unidentified, or at least I don't want to identify this person's last name. So, my previous employer owes me $4,000 in unpaid wages. They aren't responding to me at all. What should I do? So if you're provincially regulated, most likely, so each jurisdiction varies. You may have an action, a civil action in court. In BC, for that, you would, if your wages are contractual or implicitly contractual, so you've been getting paid these wages over a long period of time, you could sue, but you probably more likely, and the jurisdiction generally falls under the employment in BC only, under the employment standards branch, and you'd want to bring an employment standards branch complaint. You've got a 6-month limitation period to do that from the date of when they stopped paying you or when these wages were owed, right? So if this is $4,000 worth of wages over 8 months that they haven't paid you, then if you bring the complaint today, the initial 2 months of lost wages are I believe it might go back a year. I'm actually unsure on that with the branch, but you've got 6 months from the infraction to bring the complaint, and you probably want to do that in BC, especially for such a small amount. But it varies from jurisdiction to jurisdiction, so you'll want to look into that. But if you're provincially regulated, and I know I haven't really outlined what that is, but 90%, 95% of employees in Canada are provincially regulated. The ones that are federally regulated are matters that are interprovincial in scope, so pipelines that cross interprovincial boundaries, banks, telecoms, airlines, trains, that kind of thing. That'll be federal regulation, and there's a different avenue of redress for you there. But certainly, chances are you're provincially regulated, and if so, you're probably going to have to bring an employment standards branch or an employment standards complaint. We'll say it's probably the easiest way to do it. However, just be aware that the jurisdiction over unpaid wages might vary province to province, and so your remedy might actually be through the courts. But your best bet is in BC anyway, is through the employment standards branch, and you've got a 6-month limitation period to do that. So you'd want to move on that quickly. Same person. Same question. Okay, so Christina asks, can you record video meetings with your employer? So is this where you're on Zoom and you decide to hit record? Well, they'll know if you do that, if you're on Zoom, for example. But if you're, I guess, on your computer, you can just record it that way. I don't really think that's different than recording an audio conversation. And so I've had lots of clients over the years who've recorded, key meetings with employers at certain times, and those meetings can actually be very helpful in terms of evidence down the road. if there's a dispute, because the employer might say one thing, but it turns out in the meeting they said something entirely different, and that can be the thing that tips the needle into value. However, or moves the needle into value, I should say. But there was a case in BC where the employee recorded every interaction that he ever had on audio, I believe it was audio, with the employer, and the court found, along with a basket of other evidence, that this was sufficient to discharge a just cause termination, i.e., zero severance. I think it was after acquired cause in that case, and found that behavior to be inconsistent with, I guess we'll say, the trust necessary to have an ongoing employment relationship. So, to answer your question, Christina, yeah, you can do it, is my understanding anyway, but you don't want to do it too much. You want to pick sort of select major events. So quite often when people know they're going to get disciplined or terminated, they'll do it, and that can be of assistance. But you don't want to record absolutely everything. And it's sort of, I guess the way to look at it is you want to have clean hands in the situation. So are you recording it to protect yourself for a very good reason, given the situation at the moment, or are you recording it for we'll say malicious reasons? So yeah, I'll just leave it at that. But be judicious and careful if you're going to do that. We have it's Christine again. We have a company-wide meeting scheduled about remote work. I'm a remote worker and worried they're going to try to change this company-wide, and that's happening across the board. I think Amazon famously just announced that they're doing that, and so each company has different models that they do. Some people are allowed to work, or some companies allow their workers to work entirely from home. Others require sort of a hybrid mix. You're in the office 2 or 3 days a week. Some require full-time return to the office, and so generally speaking, on that, if you were a worker before the pandemic, or sorry, you were an employee of your employer before the pandemic, you're going to have almost no recourse in terms of if the employer says come back to work on these terms, 2 days a week, 3 days a week, whatever, you're going to have to go. And if you don't, you will have either abandoned your position or I guess committed insubordination, and they can terminate you without paying you any money. So you're going to have to do that. You don't have any legal recourse because you were doing it before, and working from home was sort of a hybrid blip situation that happened because of a once in 100-year, once in a century event, which was the pandemic. Pandemic has been sort of quote unquote over for some time now. And if you're continued to be allowed to work from home, could you make the argument that working from home is now an implied term of your contract of employment? Yeah, I think that would be a really tough argument to make in front of a court. And until there's a legal decision that says that, I don't think you want to be the first one across the line with that argument. Somewhere in Canada with that decision, because that's going to be something that eventually is contested, I would imagine. But I wouldn't want to be the first employee across the line trying to do that, because I suspect that's a losing argument. Where you might have some scope to fight on this is if you were hired during the pandemic specifically to work remotely, or subsequent to the pandemic to work remotely. So if it was a fundamental term of your employment from the start that you were working from home or you were working remotely, then yes, I would say it is very possible that saying to an employee in that circumstance, you've got to come to the office, that is a breach of a fundamental term of your employment such that you've been constructively dismissed. And I think you might have good scope to argue that. So, but even with that, I haven't seen that be an accepted argument in Canada. And you may wish to, if you want to make that argument, you're going to want to talk to an employment lawyer first, because you never want to pull the trigger on a constructive dismissal before getting legal advice. So if you need to get legal advice from us, you can do so. You'll see it on the screen, employmentlawyer.ca, helpandemploymentlawyer.ca, and 1-855-821-5900. Okay, I think I've covered that all through. Please continue to, if you have any more questions, Christina, please let us know, and I'll tackle them if you can get it in the next 10, 12 minutes. Pardon me. Okay. Kevin asks, I was terminated in 2020, even though they classified it as a retirement. They did this right at the beginning of the lockdown. Can I claim it as a constructive dismissal and receive severance pay? So, all right, Kevin. So, number one, you're out of time. Let me just see here. So you should be out of time. So if you're terminated in 2020, you've got, generally speaking, limitation period of 2 years. However, because of the pandemic, again, I don't know about other jurisdictions, BC extended it by 8 months. So the question is the limitation period by 8 months. So if from the date of your termination, so if you were terminated in December 30th, 2020, 2 years, that's December 30th, 2022, 8 months, January, February, March, April, May, June, July, August, you're still out of time, most likely. So I would expect, and I don't know what your jurisdiction is, and I don't know what most jurisdictions would have extended limitation periods due to the pandemic because the courts were closed. You may want to talk to a lawyer immediately, but I suspect you're out of time to bring any sort. Because when I say limitation period, what I mean is there's every jurisdiction has law that says, well, you've got a finite amount of time, usually 2 years, to sue someone for a civil action, 2 years from the date you discover it. So in your case, you discovered it the moment you were terminated, and you had 2 years from that point to sue, because the idea is, well, people can't live on tenterhooks, or companies can't live on tenterhooks for forever wondering if they're going to get sued. And so that's the period of time that legislatively most jurisdictions, legislatures have chosen. So you're probably out of time. However, with respect to were you tired or did you retire? Sorry, were you terminated or did you retire? No, it happens. They can tell you. I've seen employers all the time, or I shouldn't say all the time. I have a number of times seen employers say, well, they retired, but the employee didn't in fact retire, and you can then treat it. It's not a constructive dismissal; it's just a termination. Now, the issue there is it turns entirely on the facts, right? Because you're going to get a he said, she said situation where you've got two parties saying that different things occurred. Now, generally speaking, in the burden in that situation is on the employer. Employer's got to say, well, because there's no real difference between a resignation and a retirement, and so the employer's got to show, well, this is why I didn't pay severance out, because there's a presumption of severance that occurs at law when you've been terminated without cause, and they're going to say, the employer's going to say, well, no, he retired, but it's on the employer to prove that you did in fact retire, and they need some amount of evidence of that. So if you sent an email saying I retire, then that may be sufficient. But with resignations generally, and I know I'm talking more about BC here, but I think the law is more or less similar across Canada. The employer's got to show that, because people resign in the heat of the moment, and the employer's got to show that you did in fact resign and objectively did resign, or in this case retire. And saying, hey, and I see this one a lot, where an employee will say, yeah, I'm probably going to retire next year. And then next year rolls around and the employer says, you're done, you've retired. That's not a retirement. That's a speculation. It's not a concrete plan. And the employer is choosing to take that public speculation musing as a retirement to its own advantage. So it doesn't have to pay, because a lot of times when you're retiring, you've been there for a long period of time, and there's a significant amount of severance potentially coming to you. So that's not a retirement. There has to be very clear, with an end, I would say with an end date, where you're saying, I'm going to retire on this date, or at the end of June, I'm going to retire, or whatever it is. So yeah, I think you might have had a case there, depending on what the facts are, but I think you're out of time. So I'm sorry to be the bearer of bad news, but you're very much likely out of time. However, I don't know what jurisdiction you're in, so you may wish to talk to. Actually, you probably should talk to an employment lawyer right away. Just find out if the limitation period of 2 years plus the extension of time that may have existed in your jurisdiction due to the pandemic closing the courts. If you can fall within that, you still might have an action, but you need to sue immediately. But I suspect, more than suspect, you're out of time. But talk to an employment lawyer right away. If you need to get a hold of us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay. Bill asks, my doctor noted I need to try to return to work after short-term disability. My employer refused to return to work and accommodate my interests, ignoring my emails, or accommodate my requests. I filed a Canada Human Rights complaint and let the employer know. However, the employer stopped payment, is pushing me to apply for LTD, long-term disability. There's nothing I can do, or just wait for the CHRC. Well, you want to make sure you're federally regulated first, and I don't know if you're union or not. Assuming you're not, but you're a federally regulated employee, you want to make sure that you are federally regulated, because the CHRC in a non-union context applies to federally regulated employees. If you're not, and the reason why I'm saying this is this: I believe the CHRC has a 1-year limitation period, as does certainly BC for the BC Human Rights Tribunal. BC Human Rights Matters. I suspect other jurisdictions have, for as far as human rights matters are concerned, a shorter time window, about 1 year, but I don't know. But you want to make sure that's you've got that one correctly, because if you don't, you don't want to be a situation where you're out of time and you have to file provincially. So you want to look into that. You need to make sure your medical ducks are in a row. So if your employer under the human rights regime that applies to you, be it Canada human rights legislation or provincial, your employer has a duty to accommodate you to the point of undue hardship. So the question is it undue hardship in terms of what accommodations you're asking for? So I'll give you a ridiculous example, but if you're a baseball pitcher, and it's ridiculous for a number of reasons, but not least of which it's a unionized situation and a collective bargaining situation, but arrangement. But if you're a baseball pitcher and you're right-handed and then you lose your right arm, you're not going to be able to do the job. There's no, it's obviously an undue hardship from an accommodation perspective, and your employment is probably or is frustrated at law. So your employer doesn't owe you anything in that situation. But quite often with these things, it's, I work in construction, or I'm a longshoreman and I hurt my back and I was out for 6 months, but now I want to come back, but I can only lift at 75% capacity. And so the question is that an undue hardship? And the burden again is on the employer to prove that it is, or if they don't let you come back to work, that your employment has been frustrated. It gets frustration, medical frustration is just simply that the obligations of your employer, including severance, to you are extinguished due to the intervention of a third party. So you get in a car accident, no one could predict it, but you can't do your job anymore, and you're not able to return to work for 2 years, and there's no possibility of you returning to work in the near future. Then your employment is extinguished. Okay, so you have an interesting choice, and you need to talk to an employment lawyer right away. You can there's two different tracks of this. And they overlap a lot, but they are discriminating against you theoretically if the accommodations you're asking for aren't, so for example, you're required by your job to lift 75 pounds, but you can only lift 55 pounds, and you need some assistance for that. Is that an undue hardship on the employer? Well, if they've only got one employee lifting and that employee is you, it might be. But if they have 2,000 and you're working a port, then probably not. So you can wait for the human rights regime to resolve that, but the human rights regime is incredibly backlogged, and you might be waiting years and years, depending on your jurisdiction, to get it resolved. However, you could, and I don't know your situation and how important this job is to you, and being in it to retirement, et cetera, is, you could, depending on specifically what your requirements are, if it's clear that you can return to work and they're just not letting you, you could treat it as a termination, and claim constructive dismissal. Well, you can just claim it as termination, or in the alternative, it's constructive dismissal. Um, but you want to make sure in that situation. So number one, if you do that, you're never going back to that job, and you're going after severance. You need to assess whether or not you have a substantial or a significant enough amount of severance coming to you to make that worthwhile for losing the job. And you need to make sure your medical ducks are in a row. So you need to provide all the medical disclosure to your employer, and you need to be going to the doctor frequently in terms of assessing what your medical situation is. So, for example, is your change permanent? Because in a situation where you're claiming that you've been terminated, your employer's only defense is medical frustration, and medical frustration requires, or frustration in general requires, that you are unable to do the job, because of, I guess in this case, the injury, on a permanent basis. So if you have a medical opinion that says probably in 6 months you'll be 100% able to lift 75 pounds again, there's no way it's medical frustration. So these types of types of fact patterns are very, very difficult, and so you can't do it on your own. You 100% need to talk to an employment lawyer, and if you need to get a hold of us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. How many questions do we have left? Oh, a lot. So I'll try to race through a few of them. Christina's back. She asks, what does after acquired cause mean? Should I be worried about that? So after acquired cause means that the company fired you without cause, paid you some severance, and then afterwards, or maybe not, but after you've been terminated, discovers conduct that you did while you were working that, had they known about it, would have permitted them to terminate you for just cause, paying you zero. So quite often employers will terminate employees. That employee will bring a claim for common law severance. The employer will then go through that employee's company phone records and expenses and all that stuff, and try to find anything that might be worthy of, or rise to the level of just cause, and then claim after acquired cause to get out of any severance claim. That's generally what it means. So should you be worried about that? It depends on what if you've done anything that would be worthy of a just cause termination, and equally as importantly, if the employer can get a hold of that. So if you have a company phone and you're constantly texting your junior employees disparaging things about the company, famously that could do it. So, but again, that's heavily turns on the facts. You should talk to an employment lawyer if you have concerns about that. And I'll do the numbers recap at the end of this, but I just want to see if I can get through a couple more questions. So, person's name is not identified. I accepted a 6-month contract with, we'll say, a government entity. Before my start date, I was told that the department had cut its budget and the offer for my position was withdrawn. I've already resigned from my previous job and trained a replacement. Is there anything I can do? I can't even receive EI because I left my job voluntarily. Well, you might be able to receive EI because you have an accepted offer. So you can talk to Service Canada about that. But that's a great question, actually. If before you start working, do you have a severance claim because they breached their contract to you? Like, what is your actual loss? You might have, I don't know the answer to that question. You might have one. So if it's before your start date, you're still an employee, you just haven't started yet. You might have a common law severance claim, depending on what the four corners of your contract say. I would really want to look at that. You should talk to an employment lawyer right away to assess that. My condolences to you for that. That is a really unfortunate thing that happened. That's the kind of thing you just don't expect an employer to do. But obviously, you've lost the other position, which was the thing that was important. So, you might have a severance claim. I don't think you have a breach of contract claim for loss of opportunity or anything like that. But you should talk to an employment lawyer right away to see if you do. That's a really interesting. I don't know the answer to that question off the top of my head. I'd take a shot at it though, most likely. And oh, my screen vanished. Okay, I've got one question left. I'm going to try to get through this, and then they are, these are okay. These are long-term disability questions. Although one is, they're all the same person, and we'll call this person Kat. And I want to see if I can answer this because I don't practice disability. Um, my LTD of 2 years is running out on September 29th. Even if I don't feel ready to go back to work for community health worker, how can I appeal? Well, I don't want to say who your employer is. And you seem to be a union worker. You have questions about COVID vaccination still required. You don't want to take it for religious reasons. That ship has really sailed on that. You can try to give them a religious exemption document, but probably it's not going to fly. Would you be eligible for severance pay? So if you're a unionized worker, you want to talk to your union representative. Also, I don't practice disability law, so I'm going to direct you to Tuesday morning. We have one of our great disability lawyers, Martin, is doing a live Q&A. So Kat, if you could come and join us then and send your questions in, I think that would be with respect to disability. I think that you'll get them answered there. Regarding the severance question, I mean, it depends on if it seems like you work for a union, so I'm just going to refer you, or you're in a union subject to a collective bargaining agreement. So I'm going to refer you back to your union representative, who generally speaking can handle those questions for you. So we'll leave, but join us for your disability questions. Join us on Tuesday at 10 a.m. to speak to ask your question of Martin. Okay, listen, we're out of time. Great questions, a lot of questions. I wish you guys all a safe and happy, enjoyable weekend. I'll see you here in 2 weeks. Thank you very much for joining us. Thank you for your great questions, and we'll see you in 2 weeks. Have a great weekend.